Good afternoon. My name is Laura James and I am the Legal Director at the Howard League for Penal Reform. I would like to welcome you all to this afternoon's launch of our films on sentencing young adults in the criminal justice system. And in particular, I would like to start by thanking the Transition to Adulthood Alliance, who've made this work possible, but also our colleagues in HMPPS who have kindly hosted this as a live Teams event. It's our first live Teams event as an organisation, but we've done this to make sure that as many people from the probation service and the judiciary can join. And we were really delighted that we had around 300 sign-ups for this launch event. So without further ado, I'm going to just very briefly introduce our colleagues before passing over to each of them to say a few words about their interest in this subject. And I will also provide a little bit of just a few moments of background about the Howard League's work with the Transition to Adulthood Alliance on sentencing young adults and looking at issues of maturity. So our panel tonight consists of Her Honour Judge Rosa Dean, the Honorary Recorder of Harrow Crown Court. She's a member of the Sentencing Council and has just finished a 5-year stint on the continuing training for judges and recorders. She features in the films that we have made about young adults and sentencing. She is one of the stars of the show, shall we say. We also have with us Fuchsia Allen, who has over 30 years work in the probation service. She's worked across most disciplines within the service, but she's particularly passionate about getting pre-sentence reports right to make sure we get good sentence decisions. And we also have with us tonight Gary Green, who is a barrister at Doughty Street Chambers, who routinely appears in a whole range of serious crime cases. But he in particular is also one of the stars of the show in terms of the young adult movies that you're about to see. But he has a long-standing relationship with the Howard League and has been also a huge grassroots worker working with lots of young people, known very much as a community lawyer, and also recently was on our Black Lives Matter advisory board for our guide for combating discrimination in the criminal justice system in practice. And last but not least, we're delighted to have Karen Hammond with us today, who is a district judge in the Magistrates Court sitting in the South East region, but in particular she also has just started as a 4-year post as the Judicial College Director for Youth Court Training for the District Judge Magistrate Bench. So really delighted to see you here today. I just want to just very briefly say a few words about the background to what we're launching today. This is the culmination of around 4 years worth of work jointly done with the Transition to Adulthood Alliance, who have worked incredibly hard over a large, for many years now, on really developing knowledge, research and promoting good practice in the criminal justice system when it comes to the 18 to 25-year-olds. But this particular stream over the last 4 years has been looking at the issue of maturation in sentencing. Tens of thousands of young adults are sentenced every year in our courts. And many of them, of course, end up in custody and on my caseload. So the issue, of course, as we all know, is you don't wake up on your 18th birthday with all the full attributes of adulthood, as the Lord Chief Justice himself has said. But over the last 4 years, we've really been developing our thinking around this, and you'll be able to see all the work we've done on our website. It's all very accessible and available. But we started in 2017 by looking with a report called Judging Maturity, which analysed over 170 senior court judgments, Court of Appeal, High Court minimum term reviews as well, looking at judicial treatment of issues of maturity. And that research found that the courts actually were very good at that, but they needed to have the right information. over the following few years, with the help of the expert advisory board, we developed the case, and that, of course, fought for a different approach for young adults. And we developed a short paper with the principles setting that all out. But really, the kind of headlines are that the 18 to 25-year-old group ought to be treated as a distinct and separate group, that custody should be a last resort for adults, that when you're imposing custody on a young adult, you really need to think about the impact on their well-being, and the mitigating factors need to be tweaked through the young adult lens, thinking about issues of development and maturity. Now, the Sentencing Council has done wonders with this, as in fact have the Court of Appeal in terms of really developing the thinking around this, so that by October 2019, we had expanded explanations that really give a very, very detailed analysis of what it means to sentence young adults differently. But what we wanted to then do was to make all of this development really accessible to probation officers, accessible to lawyers, accessible to judges. And that's what these films are about. So I'm going to stop there. I'm delighted that the films are being launched. They are really about getting the headlines of this development in law and practice out there on the ground to have an impact and to get the right outcomes for young adults. And I'm going to now turn to each of our panelists, who are going to just introduce themselves briefly and talk a little bit about the relevance of the films and this topic to their own area of work and how they think the films might assist. So I will firstly turn to Judge Dean. Thank you.
Thank you very much, Laura. Well, listening to Laura reminds me of the first time I had to deal with a group of 17 to 19-year-olds that I had to sentence just after I'd become a circuit judge 10 years ago. And when I asked a more senior judge for some advice, the answer was, well, if they look like adults, treat them like adults. And I think listening to Laura really confirms that we've come a long way since then. And I think the expanded explanations make it very clear why. So my day job as the resident judge up in Harrow is really managing an 8-court centre. We deal with an awful lot of 18 to 25-year-olds for a vast range of offences, some of them extremely serious and some of them less so. And it seems to me also that in the very busy churn of the daily list in the Crown Court, that it's often very easy to overlook the fact that these young adults need proper consideration. I'm very conscious of it, partly because I'm a mother of 4 sons aged between 17 and 27. And as they're not listening, I can tell you now that the 17-year-old may be a lot more mature than the 25-year-old. It's just not a number. And what I think is so important about the films in this session is the very kind of practical approach that's needed and how easy it is to overlook the levels of maturity for this particular age group, and how important it is for sentencers not just to go straight to the sentencing guidelines for the specific offence and then to look at all the aggravating features, but to actually go to the mitigating features and examine properly where the 18 to 25-year-old guidelines come in and where the mitigation may be in terms of culpability, but also in terms of personal mitigation. And so working with you, Laura, on these films has really just reminded me that this is just an area that needs more focus, and it's very easy to overlook on a day-to-day basis. So I think these films are a great achievement, and I look forward to being asked some questions about them later on.
Thank you so much, Rosa, and I'm sure there will be lots of questions. I ought to have said that for those who are listening, if you have burning questions, please put them in the Q&A function, and we will do our best to ask them once we've shown the clips. Can I now turn to Fuchsia Allen, please?
Hi, Laura, and thanks for inviting us and allowing us to work with you on these videos. We've been really impressed with the quality and the accessibility and the ability to bring the user voice into it. I think that's what differentiates these videos from the materials that we currently have within the organisation. From a probation perspective, we are very interested in providing the judiciary and sentencers with information and maturity assessments to inform their sentencing decision. Very often the balance between the speed of justice and the provision of information, they aren't always aligned, and we want to work with HMCTS and the judiciary to find ways of providing that information without delaying justice. We welcomed the Magistrates Association report that was published earlier this year, that promoted the need for the judiciary to understand maturity and to get those assessments. In order to improve the quality of our assessments, we've been doing a lot of work over the last 2 years. We released some lectures to our staff so that they could better understand the psychosocial maturation process and get that theoretical knowledge to underpin their assessments. And then we provided them some very practical guidelines, which was called a maturity aid memoir, and it's providing the kind of questions that can elicit the information that you need, because it's quite easy to mask your levels of maturity, and therefore you need to unpick that a little bit. I'm going to hand back to you because I know you're going to ask some more questions, but thank you again for inviting.
Absolutely, and I must say it's been a real pleasure to work so closely with probation on this, because it's absolutely key to getting the right information out there. So I'll briefly now turn to Gary, please, if you could just give us your brief insights into the relevance of this for practitioners. I think, Gary, you need to be unmuted. Excellent. Gary is still muted. No one should ever silence Gary, but I might turn to Karen while Gary sorts his mute button out. Karen, would you like to tell us your views?
Yes, thank you. Likewise, thank you very much, Laura, for inviting me. My particular interest in this is, of course, sentencing not young adults, but children and young people in the youth court, age 10 to 17. But I do, of course, sit in the magistrates court, and I also sit, therefore, to sentence young people. And mindful indeed that 18 is not a cliff edge, as any parent will tell you, the principles which are explicit in the Sentencing Council, sentencing children and young persons, the definitive guideline, are invaluable in the youth court. But one of the key messages that I'm keen to share is just how much resource is available to those who sentence young adults, if only they were to reference the guidelines. And of course, the presumption in the youth court is that custody is a last resort, and the objectives of sentencing in the youth court are welfare and to seek to prevent re-offending or re-offending. And within those guidelines, there is, I venture to suggest, an immense source of information for colleagues who also have to deal with those who attain the magical age of 18, but of course don't achieve maturity. In the youth court, I cover the South London boroughs of Lambeth, Southwark, Greenwich, Lewisham, Bexley and Bromley, and I am very familiar indeed with the complexities and seriousness of the crime that those young people commit. And I'm very much looking forward to fielding questions, I hope, from you and others.
That's lovely. Thank you very much, Judge Hammond. And of course, the Court of Appeal has endorsed your view there in the case, particularly of Balogun, I think, saying that the guidelines don't cease to be of application just when someone turns 18. So shall we now try Gary Green and see if he's able to be?
I'm hoping that you can hear me. Can I be heard? Can I be heard?
Yes.
Oh, wonderful. Thank you. I mean, I think first of all, what I want to do, notwithstanding my practice at the criminal bar for the preceding 20 years, I want to dovetail it with my experience working with young people outside of the bar. And I've been involved in a mentoring stroke rites of passage program for young boys between the ages of 13 and 17 for a period of now about 15 years. One of the questions that we ask of those parents and those young people who come onto the program is, when did you become an adult? And we get so many varied different answers from the audience, both parents and young people alike. Some people will identify the point at which they turn 18, which we're discussing now, and we know is not a cliff edge. Some will say when they left home. Others will say when they got their first job. Some will say when they became a parent. And that nebulous notion about when you become an adult carries on into the criminal justice system also, because we know that children are defined under the age of 18. But within the criminal justice system, there is no proper definition of young people between that age and 25, so between the ages of 18 and 25. Yet despite that, we know that some of the vulnerabilities and the issues which impact those young people under the age of 18 continue to impact those who are over 18 as well, in a very significant way. And certainly in my criminal practice experience, I see that on a routine basis. So it's really important, I think, that we identify, in the same way that we identify vulnerabilities for young people under the age of 18, that those vulnerabilities persist and the maturing process continues, and that we look at some of the authorities at the Court of Appeal have, in fairness, for some time been handing down, some of which go back to 2010, perhaps some earlier, but some significant authorities that go back to 2010, 2011. There's a really important authority of Clark, there's an authority of Daniels. And I think we just need to be aware of the impacts of the continuing process of maturity and really bring it to the attention of our, especially our sentencing tribunals, so that decision making can be seen in the proper context. So that's all I'll say for now, but I know that as I said, there'll be further observations and questions.
Okay, thank you very much, Gary. We're now going to hear the first clip.
But what happens when a child turns 18? The Lord Chief Justice observed in the landmark judgment of Clark that turning 18 does not represent a cliff edge. Full maturity and all the attributes of adulthood are not magically conferred on young people on their 18th birthdays. Experience of life reflected in scientific research is that young people continue to mature, albeit at different rates, for some time beyond their 18th birthdays.
I'm 29 years old. I've been involved in the criminal justice system since I was 12, 13. At age 11, when I went to secondary school, I discovered that I had ADHD and dyslexia. And of course, through the things that I did experience as a child, I found a lot of things difficult, sitting still, spelling, reading. As I turned 18, none of these problems seemed to disappear. They just got worse and multiplied.
Okay, thank you so much. That first clip really just sort of sets the scene there in terms of the cliff edge that so many of our speakers have already mentioned. So in terms of the cliff edge that's described there by the young person and in the images, I'm sorry if not all of them were immediately visible, but of course the films will be made available to everybody. I just wondered if we could ask some of the panelists, perhaps starting with Rosa, whether you could recognise what Paul describes here in terms of those increased expectations on reaching adulthood, but the sort of absence of the problems that young adults face. Perhaps, Rosa, I could turn to you first.
In a word, yes, very familiar. And I think very well expressed, and of course, you know, not a coincidence that our speaker had so many problems to battle with as he was growing up, and it really just echoes what was being said earlier, just about the absolute importance of having all the right information, because it could be very easy just to treat him like an adult and just rush through without pausing to actually reflect. So very familiar.
Thank you very much, Rosa. I've just got a message. If everyone's able to keep their cameras on throughout the event, that helps the backroom ladies to make everything work, if that's possible. And then perhaps now I could turn to you, Fuchsia, in terms of your perspective on that first clip.
Yeah, obviously, we see that. My focus is very much in the court space and the differential between how a youth court runs and how an adult court runs. They are poles apart. The service that's given to a young offender or a young person will be a longer German, a very detailed report that will draw on schooling, parents, for the young adult who is now 18 years old and 1 day. It may be a stand down report that's informed by a very short interview. In recognition of that, the most recent white paper introduced a PSR pilot, which is now running across 15 sites, where we have made agreements with local judiciary and HMCTS to write longer reports and have slightly longer to write reports on this group to see if that actually improves the outcomes and the sentencing decisions for 18 to 25-year-olds, and that's with a wraparound of support for the probation officers in those courts, so that they're fully equipped to meet those needs.
Thank you very much. That's really interesting, and be really really waiting to hear the outcome of the pilot. So I think now if we could move to the second clip, which is all about the need to factor developmental needs into sentencing, which we've all already referred to in our discussion.
The frontal lobes are the areas of the brain which are thought to be responsible for things like controlling emotional impulses, logical planning, and future-orientated thinking. It is no coincidence that the peak ages for criminal behaviour are 16 to 25, as these young people are more likely to take risks, are more likely to be influenced by their peers, and are more likely to fail to factor in the longer-term consequences of their behaviour.
There is now a growing understanding of how a young adult's brain develops, and how this can contribute to the risk that young adults get into trouble with the law.
The sentencing guidelines makes it very plain that a lack of maturity may reduce the culpability, the seriousness of the offence, and may also be highly relevant to personal mitigation. It's our job as sentencers to pass fair sentences, and we can't do that with 18 to 25-year-olds if we don't have the right information, if we don't understand the level of maturity of that young adult, and if we don't understand about their personal circumstances.
Thank you. So now thinking about that clip there and really sort of delving into the brain development aspect, could I now turn to Gary and ask him how, as an advocate, how do you make sure these issues are actually fully considered by the court?
Well, I think in the first instance, it's having an awareness. And that awareness for me has come about not just through practice, but as I said earlier on, it's working with young people outside of the working environment. But I think it's really important as a criminal advocate to listen, quite frankly. Listen to what a young person has to say. Listen to those experiences, and don't just use the young person as a resource where you have their consent. Engage family members who can be a wealth of information, who can speak about the particular behaviours or conduct or immaturities that they are familiar with. For example, you may well have somebody who presents at court appearing to present as an adult over 18, but if you speak to their parents, for example, you'll find out about really immature behaviour at home. For example, something as minor as silly as not being able to maintain a proper practice at home, like cleaning their room, for example. So I think it's really important that you try and gather as much information, both from the young person themselves and their support networks, and get a rounded perspective of the individual. so that you can present a humanised version of that individual to the court, with their vulnerabilities and their weaknesses made aware. And there's a wealth now of information, there's a wealth of reports that are available, the sentencing guidelines, the equal treatment bench book. There is really a wealth of information that really should alert practitioners to the need to really be concerned about issues of maturity and how to properly address them.
Thank you very much, Gary. And I do think that sort of takeaway, trying to get a humanised version of your young client before the court is really important, and particularly in the current kind of climate where there's so much remote contact. Sometimes it's really hard to actually to find your clients.
Well, I should say, Laura, I don't advocate remote hearings for sentence. I advocate remote hearings in many other examples, but for sentence, especially if you haven't had a long relationship with your client, it's really important you get up close and personal. And as I say, rely upon those support networks where they exist.
Thank you. So perhaps I'll just briefly turn to Karen Hammond then, and just to ask you, thinking about that clip we just saw and that very discrete sort of developmental journey that young adults are often still going in, do you feel that you actually get enough information to factor young adults' developmental needs into your sentencing decisions? And perhaps if Karen is unable to, perhaps I could readdress that same question.
Sorry, Laura. I was going to say I agree absolutely with what Fuchsia says, because there is a huge gulf in my experience between the information I get in a pre-sentence report from the youth offending team, which would have all the information that I need and in depth and considered in the main, and the imperative often to do stand down reports in the adult court and telephone reports and oral reports at court. So yeah, the 18 really is a cliff edge in my experience from the point of view of the amount of information. And of course, advocates might assist courts by gently reminding their tribunal that there's a statutory obligation to follow the guidelines. And for example, if a young adult has learning difficulties or mental or developmental needs, then in accordance with those definitive guidelines, the mental health guidelines, they must be taken into account as well.
Absolutely. Thank you very much, Karen, for that insight. I think we will now then turn to clip 3, which is about young adults' trauma and the need to really tailor your support and approach to that, to their experiences. I'm afraid there seems to be a problem with the sound.
Serious mental disorders often emerge in early adulthood as this trauma processing begins.
It's vital that those working with young adults in trouble with the law understand these issues and the hidden damage that may not be obvious at first glance.
Having a professional around that cares is important and could change your life. The professional needs to have the qualities of listening, not judging, being able to engage easily with the individual.
Trust is a really important factor in representing young people. It's important to have a non-judgmental approach, to be vulnerable and open, and to hear their stories so that you can properly articulate mitigation, for example, on their behalf, which gives the court a proper insight into their experiences, some of which may be significantly dysfunctional.
Okay, so thank you very much for playing that clip. Perhaps I could now turn to Fuchsia, just to ask you a little bit more in depth about how the pre-sentence reports can ensure that young adults' experiences of trauma and unmet mental health needs are recognised and picked up in the pre-sentence reports.
Well, I think there's two things to focus on here. First of all is the actual pre-sentence report interview process and the need for our officers to ensure that procedural justice principles are met. It links back to the area Gary was focusing on, in that a young person needs to feel that they understand what the process is and that it's fair and just in order to engage with that process. We're asking them some very intrusive questions, and we're asking them without them having a relationship with us necessarily. The second thing to highlight is that we can undertake a very good maturity assessment and communicate that to the judiciary and to the court, but actually it's the so what difference does that make in terms of our sentencing proposal? Because a assessment of maturity on its own makes very little difference, and therefore we ask our officers to tailor interventions to better meet the needs of those individuals and consider the wraparound support a young person might need in order to successfully complete a community disposal, or what the impact for this young person and the possibility of disrupted maturity a short-term custodial sentence will have. So it's very, very important that we get the so what across to the judiciary. The onerousness of an order for a young person may be far greater than for a similar order for an older person, and to communicate that to the court. So actually a 50-hour community order or a 50-hour unpaid work order would be incredibly onerous for somebody who had lower maturity and poorer coping skills.
Thank you very much. That's really, really helpful, Fuchsia, and certainly working with young adults in custody, there are so many features of their experience there that we eventually discover are re-traumatizing, which clearly weren't known at the point of sentencing, which one wishes you could travel back in time and make sure that information was there. Quick question for Gary, and very quick so that we can keep on schedule. With do you think lawyers, we don't get any particular training in dealing and working with actually incredibly traumatized and vulnerable young people, and I think that's a big gap. But I'm interested in your perspective, Gary. Do you think lawyers need to skill themselves up or need better training to make sure that they are alive to these issues and know how to deal with them?
I do, actually. A very considerable amount of the barristers' early years of practice are in the youth court, and I know that the Inns of Courts themselves provide some youth training for prospective pupil barristers who will regularly and routinely appear within the youth courts. But I think thereafter it's an area of practice which I think many practitioners almost feel like they are being promoted from as they move away from the youth court into the adult magistrates court, and then predominantly, if not exclusively, in the Crown Court. But those issues which impact young people and children within the youth courts still impact those same young people or children when they do appear, but I know we're concentrating on young people. Those issues still impact those young people within the Crown Court system. And the Crown Court system, with the robes and the gowns and the wigs and the uniform, is arguably far more alienating than the experience of the youth court, where people sit in an environment on the same level, and the judiciary obviously up on high. And so I think it's really important that we have at the forefront of our minds that these issues don't go away simply because you're not appearing in the youth court. That the training that you may have had, and I do say may have had, in your court should be supplemented with other training outside of the profession, and being able to engage young people where we can. I've been fortunate because of my voluntary work with young people, but there is a great deal of mentoring work outside as well, which exists, and I think that engagement with young people keeps at the forefront of your mind the need to treat young people differently. So yeah, I do think we should skill up, and we should also just really be aware, again, as I've said, of all the various tools that are now readily available online, at least to get an insight if there is not specific training that's been undertaken.
Thank you, Gary, and I do hope that these films will be part of that skilling up process. So we can turn now to the final clip, at the end of which I will just so that we can keep on track and have time for discussion, I will just ask Rosa and Karen to comment on. So if we could go
the
to
justice skip. Committee inquiries also highlighted the importance of recognising that there is a distinct legal framework and system for dealing with young adults. And that applies both in criminal law, but also in related areas such as social welfare law. And it's really important that practitioners, judges, and all the agencies involved with them are fully aware of that.
Those who understand the challenges young adults face can also see why it's so important to receive appropriate legal support.
There is a whole host of different legal considerations that apply to young adults between the ages of 18 to 25. First, we have the different considerations that apply to sentencing. These are set out in the Sentencing Council's guidelines and also in the rulings of the Court of Appeal. Second, we have a whole host of different considerations that apply to young people who are care leavers and who are entitled to support with finances, education, housing, and even thinking about personal and social support under the Children Act 1989. Thank you very much. Perhaps turning to Rosa then first, do you think that these specific legal considerations that apply to young adults, particularly, for example, the care leaver rights that I mentioned there in that clip, but also the expanded explanations, do you think that they are well enough known to have full effect? I think you need to unmute.
I think the short answer is no. And that's a long answer as well. And listening to what Gary was saying, it's very easy when a defendant's on bail to adjourn for a pre-sentence report, and there's plenty of time for a lot of information to be gathered. I think there's a real rush with custody cases, and a lot of our young defendants are in custody. It's just a rush to get on with it without actually pausing, because everyone's terrified that if you ask for a pre-sentence report, it's going to take 8 weeks. And that seems like a lifetime to a lot of the younger defendants. Whereas in fact, there's probably already a lot of material there, because obviously one of the reasons why they may be in custody and refuse bail is because of their record. And it may well be there's already a very detailed yacht report lurking in the background, which can be built upon. But I know my answer is still is I just think it's very easy to rush, and actually one thing to take away from today is just stop and make sure you've got all the right information, because if you don't have the right information, you're not going to pass the right sentence.
Thank you very much, Rosa, for that. And I think certainly working with young adults in custody, the point you make there is really important. So often there is information that's readily available. Sometimes young adults I know will be working with a health and wellbeing team already in custody who have an awful lot to say and may already have prepared reports actually talking about how they're beginning to engage and deal with trauma and all sorts of things that would be highly relevant but need to be unlocked. And found. Karen, do you want to comment on that and the extent to which the knowledge about the specific legal considerations needs to be better known for them to have full impact?
I mean, undoubtedly, and I was just thinking as Rosa was speaking that if you have a young adult who's recently turned 18 or perhaps even 19, if you see on their record that they have had involvement with the youth offending team, then if you shall correct me if I'm wrong, but that information is available in abundance. And all the points that Gary was making, about the importance of taking into account vulnerabilities and background and specific considerations of looked after children and custody exacerbating existing vulnerabilities, and indeed references to the Black and minority ethnic children. All of those provisions are expressly considered in this guidance, which is my absolute Bible when I sit in the youth court. And I will, if you'll indulge me, repeat that if you're dealing with 18 to 25-year-olds, a great deal of guidance is available in that first section, the general principles. And if you need to frame your mitigation within the language, it's all there for you. So perhaps if I might be permitted to bang my drum in that regard, I think there could be fruitful crossover.
Brilliant, thank you. So we're now going to just spend the last 10-15 minutes of the session just with some discussion and Q&A. I'm going to just start with a question, because we haven't talked about discrimination, and we all know that the gravest manifestation of discrimination in the criminal justice system is seen with young people in custody. Over half of all children in custody are from Black and ethnic minority backgrounds, but actually, a very high proportion of young adults are also around a third from Black and ethnic minority backgrounds. And of course, we know that so what I want to ask really is, how can we address the discrimination which Black and ethnic minority young adults experience in the criminal justice system at the point of sentence? And I'll ask Gary to come in first, and then perhaps Rosa on that, please.
I mean, I think in the first instance, there is the need for personal insight and knowledge. And we have to understand the impact of systemic racism. We have to move away from the binary that racism is good or bad, and have to have an understanding in as much as people are good or bad and adopt racist practices. We need to move away from that binary and properly understand how systemic racism actually operates, and depersonalize the impact of it. So in the sense that it's a way that the institutional culture can operate. So I think that's the first thing that we need to understand. It needs to be understood that if we're making submissions to a Crown Court judge, that we're not accusing them personally of adopting policies or practices which are racist, but we know that it's a consequence of systemic discrimination. And at the point of sentence, I think I made the reference previously to humanizing and contextualizing that the young person's experience. Adultification is one of those terms that I've become familiar with in the last few years. And it's really a process by which young people, and young Black people in particular, can become dehumanized. And there is a very narrow focus on the culpable conduct of the individual before the court, without placing that in context. Speaking of future, I had a fantastic pre-sentence report recently, I say that tongue in cheek, which the entire focus of the report was upon the conduct of the young person who would commit an offence. And one of the features of this young person is that the so-called gang that he had aligned himself with and been involved with committed offences had also paid for a funeral for a baby, his baby that had died very soon after that child had been born. And that gang, in inverted commas, it was effectively the family of this young person. And they rallied together, they offered him emotional support and financial support, and they paid for that funeral. And this particular report, and reports are usually very good, I should say, future, completely missed the context and the significance of that. So I think it's really important that we recognise that there is a process of adultification that goes on, which effectively amounts to dehumanising young people and young Black people. It's really important to contextualise their life. It's really important to humanise them. It's very important to listen. It's important to recognise the cumulative disadvantage that young Black people had in particular, which may go back as far as, for example, being excluded at school, being unfairly stopped or searched, and being unfairly charged in some circumstances, which really means that they may feel alienated, are likely to feel alienated from the system, and try and really put that young person's life into its appropriate context. So mitigation in the real sense, not making excuses, but simply placing matters into context so that they can be seen properly.
Thank you very much,
And
Gary.
as I think I said previously, you don't have to slope around the old libraries of the inner courts anymore. I used to love the pupil, but now there is so much material available online, not least the Howard League's guide on representing young Black people in the criminal justice system, a justice report, the David Lammy report, reports that go back many years, which show a consistent pattern of discrimination and the equal treatment bench book as well, the sentencing guidelines, and a number of the sentencing guidelines now identify where there are disparities within the criminal justice system. So it's really important. You don't necessarily need to wear your cape and feel brave, because there are so many reports which objectively identify the discrimination that exists. And as I say, a judge should not feel personally being targeted because somebody points out that there is a risk of a discriminatory sentence.
Thank you very much, Gary. And I think I recall that you had a recent experience of Judge being very pleased that you had raised those points. So perhaps, Judge Dean, if I could turn to you for your views on that.
Well, I was just listening, really struck by what Gary was talking about earlier about the importance of trust and the importance of not dehumanising the defendants that we're sentencing. And it seems to me, speaking personally, that the challenge for me has always got to be to make sure that I got all that information that I need. So I'm not dehumanising, but I am sentencing a person, not a statistic. And I'm only going to be able to do that if I do have the understanding about the challenges that that person has faced, the discrimination that they have faced, the problems they may have had of housing and education, poverty. And I think that's the challenge. And I think that's why it's so important. Again, the takeaway from this session is to get all the information, to always remember that you're sentencing a person. And it's so important just to pause and have that detailed pre-sentence report, or to allow counsel, the advocate, to have that long conference so that they can actually really give you the information that you need so that you can get it right. I think it's very easy to do shortcuts. It's very easy to make assumptions about people. A lot of the young defendants that I see often have no family at court. They're often very much alone. And I need to know why they're on their own, and there could be a perfectly good reason, but that information can come from the report or can come from the advocate, but it needs to be given and time needs to be set aside for it.
Thank you, and I think that's such an important point. And in fact, I had a very recent experience of a young black adult in custody who was described by workers as secretive and guarded and accused of being very heavily gang affiliated, but actually, and I found him hard to connect with initially too, but I went to see him and spent some time with him, and he was just terribly shy. But actually, he was absolutely lovely once we broke through that barrier. So peeling away some of those sort of perceptions that can feed into discrimination to see the person behind them. I'm going to just pause for a second to say thank you to Gary, who I know has to slip off at this stage, and before we go to our next question, which links, and this is also about perception, so it fits in very nicely. It's from a listener called Jenny, who asked whether visible perceptions of maturity, i.e. how someone looks, as in their size, and this goes, I think, back to Rosie, your very first opening comment, need to be specifically addressed in reports, and how can that be done in a sensitive way with the permission of the young adult. So I wonder, perhaps, Fuchsia, you might want to respond to that.
It's a really interesting point. It's not something that's actually included in any of our guidance. The I suppose physical maturation as opposed to psychosocial maturation. Jenny, I'm going to look into it. I haven't got a very good answer. I think you're absolutely right that the permission of the young adult is really important in this. Whether that's because the young adult looks much older and therefore there's perception of age there, or vice versa. But I'll have a look at what we have and what we do around that. I think it's an interesting concept.
And I mean, I don't know if Gary has left us or not already, but certainly it's the sort of thing, as an advocate or as a representative, you will be in a position to have a very sensitive and confidential conversation with a young person about perhaps raising those issues, and you might be 6'3", but you'll still not had a job and never opened a bank account or whatever. So there are ways, I think, of making those points clear and going back to that adultification point. Does anyone else want to, Rosa, is there anything you want to comment on with that, or Gary? No. There has also been an observation in the chat about sort of hidden disability. Now, the films do really cover that, and you saw a clip there from consultant psychiatrist Dr. Dalmage, but the listener here has said that they're from a mental health background and finds mental health and disabilities, especially undiagnosed conditions such as autism. And again, at the Howard League, we find that's often very prevalent and often not discovered until way after sentence. How important is it, and perhaps I'll address this to Rosa then Karen, for you to know if you're sentencing a young autistic man? I have to say, particularly, we find that lots of young black boys and men are often passed over on this diagnosis in particular.
Well, I mean, it's absolutely essential to have that information, and of course, the new guidelines in relation to mental disorders are very clear about that. And I think, on the film, we're hearing about ADHD, and that can often lead to exclusion and all sorts of untreated problems, which sort of in a terrible vicious cycle. But what, of course, would be very concerning if you had a young adult in a custodial environment with autism, that the impact on their day-to-day living as a result of living with autism could be horrendous. And could be very, very powerful mitigation. And if someone's on the cusp of custody, it can make all the difference. And this whole problem about hidden disability, it's such a powerful point, because we know from the figures, don't we, Laura? You know the figures. Just vast numbers of people in custody have mental health problems, are themselves victims of crime. We're dealing with an already massively disadvantaged section of our community. And we just can't treat people as fodder who are just being processed through the system. We've just got to actually stop and think and have the information. I'm sorry to keep banging on about it, but I just think there's such a danger of not taking our time.
Thank you very much, Rosa. And Karen, do you want to come in there?
No, thank you. The one of paragraph 1.2, in fact, the second paragraph into the child and young person specific guidelines, reminds us that sentencing is individualistic. And it strikes me, listening to all our contributors today, that the focus on the individual and reminding, as Rosa has so powerfully put it, that it's a person, not a number, again, would be well served by reminding ourselves of all the principles. The impact of custody on somebody with additional needs is expressly provided for in those same guidelines. It is all there, people. Please read it. I think you'd find it invaluable.
Thank you very much, Karen. We're going to wrap up shortly. I'm just going to have one final question from a listener, and before I thank everybody and close, which is from a listener who says there really needs to be even more training and guidance for probation practitioners regarding maturity, race and gangs when completing court reports, or working to time pressures and limited time to read and understand about these subjects, which is actually very much the reason why we have produced these films. And I should say, you've only seen clips of the films today, but each film is only 4 minutes long. We've done that because we know that it's important issues, but everyone's very busy. So the question is, and I'll put it to Fuchsia, when the question is, when or what more can be done to help practitioners and probation officers to improve their practice around here.
Thank you, Laura. It's a great place to end. As you say, I think these films are part of that package. We're currently, as part of the the Probation Services Unified, if anybody didn't know, we came back together in June and we are delighted. And I think it gives us an opportunity to give really consistent training and messages across a staff group, as opposed to lots of dispersed community rehabilitation companies. And we're also recruiting an extra 1,500 probation officers so that we can look at slightly smaller caseloads and more focus on young people. I think the question is really pertinent. As part of the future model, we are for the first time providing a continuous professional development offer to our court staff. Judicial surveys have come back and we've heard them. The judiciary want a more professional and better trained and more consistent service from us. I think we see lots of very good practice, but you're not seeing consistent practice. And our response to that is a continuous professional development offer that will be launched in January this year. Part of that is improving our practice and our outcomes for young Black and ethnic minority defendants, and work is going on with our evidence-based practice team to develop a package. There isn't an easy answer in this, and I was saddened with Gary's recent experience. And the use of the language in that report was something that you'd hope not to see. But it is, the onus is on us, because actually we're asking our staff to work in highly pressured environments and very, very quickly. Unconscious bias, all of those elements is where unconscious bias happens, when you're rushing to decisions, when you're making connections. So we are working to improve the package for our staff so that they can work in a safer way, while still supporting the court to I suppose to deal with justice quickly.
Thank you so much, Fisha. What a positive and helpful note to end on, and I very much hope that the Howard League films, they are going to be accessible, available for everyone. We hope that you will find them informative, authoritative, and we hope they will be used and watched and will help with that process that you have just described. Can I thank all our speakers, the Transition to Adulthood Alliance, Barry Cadbury. Can I also thank HMPPS for hosting this session? And of course, I must remind you, as I'm Legal Director of the Howard League for Penal Reform, that we are a membership organisation and we very much value the input and support of all our members, and you can find out more about that on our website. Thank you all very much indeed, and good evening.